Hello and welcome to the class. Today's topic is about role of national and state women commissions. It is often said that the status and position of women in society indicate the best way to understand a civilization, its progress and its shortcomings. In case of India, women have come a long way from women sages and scholars in the Rigvedic period to women in the armed forces, IT sector, politics, industry and other significant areas while balancing their role as a daughter, wife and mother. The journey towards modernization has not been easy. Women had to fight the traditional Indian male-dominated society to emerge as stronger and independent entities. While all these are positive developments, cases of rape, harassment at workplace and dowry deaths are rampant. Illiteracy and ignorance about their rights are still prevalent among majority of the women. It was in this background that the Committee on the Status of Women in India, that is CSWI, recommended nearly 2 decades ago the setting up of a national commission for women to fulfill the surveillance functions to facilitate redressal of grievances and to accelerate the socio-economic development of women. The principle of gender equality is enshrined in the Indian Constitution. The preamble promotes equality of status and of opportunity. The fundamental rights enshrined in Part 3 of the Indian Constitution and directive principles enshrined in Part 4 of the Constitution all promote gender equality. The Constitution not only grants equality to women but also makes special provisions for ensuring equality. Thus, as per the recommendations of the Committee on the Status of Women in India, that is CSWI, and in order to uphold the mandate of the Constitution, in January 1992, the National Commission for Women, that is NCW, was set up as a statutory body under the National Commission for Women Act 1990. Act number 20 of 1990 of Government of India. Women as a class neither belong to a minority group nor they are regarded as a backward class. India has traditionally been a patriarchal society and therefore women have always suffered from social handicaps and disabilities. It thus became necessary to take certain ameliorative steps in order to improve the condition of women in the traditionally male-dominated society. The Constitution does not contain any provision specifically made to favor women as such, though Article 15, Clause 3, Article 21 and Article 14 are in favor of women. They are more general in nature and provide for making special provisions for women. The Supreme Court, through its interpretative processes, has tried to extend some safeguards to women. For instance, in Bodhisattva Gautam versus Subra Chakrabarti, AIR 1996, SC 922, and the Chairman Railway Board versus Chandrima Das, AIR 2000, SC 988, where rape was declared a heinous crime, as well as the landmark judgment in Vishakha versus State of Rajasthan, AIR 1977, SC 3011. The courts have tried to improve the social conditions of Indian women. But these have hardly sufficed to improve the position of women in India. Thus, in light of these conditions, the Committee on the Status of Women in India, as well as numbers of NGOs, social workers and experts who were consulted by the government in 1990, recommended the establishment of an apex body for women. The lack of constitutional machinery, judicial ability and social interest formed the impetus and need for the formation of the National Commission for Women. It is apparent from the prior mentioned conditions and problems that women in India, though in a better position than their ancestors, were handicapped to a great extent in the early 1990s, and these handicaps and injustices against Indian women prompted the Indian government to constitute the first National Commission for Women in 1992. The first commission was constituted on 31st January 1992 with Mrs. Jayanti Patnaik as the chairperson. The Act of 1990 under Section 3 provides for the constitution of the Commission. In the light of ever-increasing cases of violations of women's rights across the country, the need for setting up effective state women commission that would ensure promotion and protection of their rights and freedoms was particularly felt necessary at the state level. The similar regulations have also been enacted by the various respective states under which the State Women Commission have been set up, and such state commissions are constituted and allowed to function their activities within their respective jurisdictions according to the acts and rules. Section 10, Clause 1 of the Act of 1990 provides a 14-point mandate for the National Commission for Women. Broadly speaking, the Commission's mandate can be divided under 4 heads. A. Safeguard of rights of women. B. Study problems faced by women. C. Evaluating the status of Indian women from time to time. And D. Fighting cases related to women's rights violations. Let us first discuss about the safeguard rights of women. These are enshrined in subclauses A to E of Section 10, Clause 1 of the Act. They expect the Commission to examine the safeguards for women provided by the law and the Constitution. The Commission is to submit reports about these safeguards and make recommendations about the implementation of the same. Secondly, study of problems faced by women. These are mainly enshrined in subclauses G to I of Section 10, Clause 1 of the Act. According to these subclauses, the Commission is to carry out studies involving the problems arising out of discrimination against women and provide remedies for these problems. Thirdly, evaluating status of Indian women. Subclauses J to N of the aforementioned section of the Act deals with these responsibilities of the Commission. The Commission, according to these guidelines, has the responsibilities of evaluating the status of Indian women under the Union government and state governments. It is to inspect and evaluate the conditions of detention homes and other such facilities in which women may be detained and deal with the appropriate authorities in order to improve the condition of such places. Fighting cases related to women's rights violation. Certain clauses in the mandate also empower the Commission to take up cases related to discrimination against women, women's right violation, and fund cases which involve the rights of a large number of women. The functions of the Commission as enumerated under Section 10 of the National Commission for Women Act 1990 are as follows. Firstly, investigate and examine all matters relating to safeguard provided for women under the Constitution and other laws. Secondly, present to central government annually and at such other times as the Commission may deem fit, reports upon the working of those safeguards. Thirdly, make in such reports recommendations for the effective implementation of those safeguards for improving the condition of women by the Union or any state. Fourth, review from time to time the existing provisions of the Constitution and other laws affecting women and recommend amendments thereto so as to suggest remedial legislative measures to meet any lacunae, inadequacies or shortcomings in such legislations. Fifth, take up the cases of violation of the provisions of the Constitution and of other laws relating to women with the appropriate authorities. Sixth, look into complaints and take suo motu notice of matters relating to women's rights. 7. Call for special studies or investigations into specific problems or situations arising out of discrimination and atrocities against women and identify the constraints so as to recommend strategies for their removal. 8. Undertake promotional and educational research so as to suggest ways of ensuring due representation of women in all spheres and identify factors responsible for impeding their advancement, such as lack of access to housing and basic services, inadequate support services and technologies for reducing drudgery and occupational health hazards and for increasing their productivity. 9. Participate and advise on the planning process of socio-economic development of women. 10. Evaluate the progress of the development of women under the Union and any state. 11. Inspect or cause to be inspected a jail, remand home, women's institution or other place of custody where women are kept as prisoners or otherwise, and take up with the concerned authorities for remedial action if found necessary. 12. Fund litigation involving issues affecting a large body of women. 13. Make periodical reports to the government on any matter pertaining to women and in particular various difficulties under which women toil. 14. Any other matter which may be referred to it by the central government. The central government shall consult the Commission on all policy matters affecting women via Section 16 of the National Commission for Women Act 1990. Along with the National Commission for Women, the state commissions are also doing some good deeds for the promotion and protection of women's rights in their respective states. Some of these can be discussed as follows. Number 1, investigate and examine all matters relating to the safeguards provided for women under various laws in their state. Number 2, presenting reports to their state governments annually or at such other times as the Commission may deem fit. Third, making such reports recommendations for the effective implementation of those safeguards for improving the conditions of women by the state. Fourth, review from time to time the existing provisions of the laws in their state affecting women and recommend amendments thereto so as to suggest remedial legislative measures to meet any lacunae, inadequacies, or shortcomings in such legislations. Fifth, take up the cases of violations of the provisions of the Constitution of other laws relating to women with their governments. Sixth, look into complaints and take suo motu notice of matters relating to women's rights. 7. Call for special studies or investigations into specific problems or situations arising out of discrimination and atrocities against women and identify the constraints so as to recommend strategies for their removal. 8. Undertake promotional and educational research in their state so as to suggest ways of ensuring due representation of women in all spheres and identify factors responsible for impeding their advancement, such as lack of access to housing and basic services, inadequate support services and technologies for reducing drudgery and occupational health hazards and for increasing their productivity. 9. Participate and advise on the planning process of socio-economic development of women in the state. 10th, evaluate the progress and the development of women in their state. 11th, inspect or cause to be inspected a jail, remand home, women's institution, or other place of custody where women are kept as prisoners or otherwise, and take up with the concerned authorities of their states for remedial action if found necessary. 12. Make periodical reports to the government on any matter pertaining to women and in particular various difficulties faced by women of their state. 13. Any other matters which may be referred to it by their respective governments. Presently in our country, in all the 28 states, state women commissions are there and they are working for the benefit of women in their respective states. Some of the workings and examples of the women commissions of various states can be discussed as follows. In April 2014, the Madhya Pradesh State Women's Commission slammed the Higher Education Department for not completing investigation in a workplace harassment complaint by one of the lady professor of Government College, Narsingagarh, and ordered the concerned department to submit its report within 15 days. The Meghalaya State Commission for Women on 13th May 2014 ordered two separate inquiries into the alleged captivity and torture of 12 women who were branded as coal girls by some activists in Tura. In similar way, the State Women Commission is also empowered to act as a fact-finding statutory body as well as a quasi-judicial authority under the State Women Commission law. It undertakes various activities including the education, health and other related socio-economic matters, especially for the welfare of women in the state. Such State Women Commission submits to periodic report indicating its activities, views and suggestions to the concerned state government. After all the discussions we had, we can now conclude that the functions of the national as well as the state women commissions are inter alia to see that the constitutional and legal rights of women are properly implemented, to review different provisions of law and recommended amendments thereto, to take up cases of violation of the provisions of the Constitution and other laws relating to women with appropriate authorities, and to look into complaints regarding deprivation of women's rights, non-implementation of laws providing protection to women, non-compliance of policy decisions or guidelines, ensuring welfare and relief to women, take up the matter of appropriate authorities, visit jail destitute girls' home, women institutions or other places of custody where women are kept as prisoners, and take up such matters with concerned authorities for remedial action as may be necessary. Therefore, one cannot disagree with the important role played by women commissions in our country, but there is a need to give more importance so that the position of women can be uplifted in true sense of the term, and the main motto of bringing the commissions is fruitful in proper sense, and our country women can be benefited out of the various activities of the commission.